My dear friends in Christ Jesus, greetings to you all. In this episode, I answer to an important question. Is a written agreement between the diocese and the religious institute necessary to carry out the ministry in the diocese? My dear friends, a written agreement is a bilateral contract in a broader sense made between the bishop and the competent religious superior, which sets forth norms out of which there arise certain mutual obligations and rights. It is to establish, regulate, or dissolve particular modes of bond between the bishop and the religious in his diocese. According to the Canon 37 of the Latin Code, the administrative acts which concern the external forum is to be effected in writing. Strictly speaking, it is not a legal contract canonized by the Canon 1290 of the Latin Code, and as such, it cannot and does not create obligations and rights in civil law. Also, there is no question of seeking commutative justice before the civil court, nor of filing a suit in the court to solve the litigations arising from the stipulations of the agreement. The paragraph 2 of the Canon 681 of the Latin Code prescribes a written agreement to be drawn up between the diocesan bishop and the competent religious superior when the bishop entrusts works of apostolate to religious. Concerning the subject matter of the agreement, the paragraph 2 of the Canon 681 states that it should, among other things, expressly and accurately define what pertains to the works to be carried out, the persons to be devoted to it, and economic matters. My dear friends, a written agreement is required and is useful but not a must canonically in other cases, especially when a religious house of an institute is erected in a diocese. According to the paragraph 3 of the Canon 678, in directing the apostolic works of religious, the diocesan bishop and the religious superiors must proceed by way of mutual consultation. At the time of foundation of a religious house, this can be surely done and decisions can be formulated through a written agreement so that the religious can carry out their apostolate in the diocese in a stable and organized manner. The Canon 612 of the Latin Code affirms that the consent of the diocesan bishop is required if a religious house is to be used for apostolic works other than those for which it was established. It implies that the apostolic cooperation in certain area or areas of apostolate according to the proper apostolate of the institute or particular need of the diocese was agreed upon by the bishop and the religious superior of the institute concerned at the time of its foundation. The Canon 790 of the Latin Code prescribes proper agreements between the diocesan bishop and the religious superior of an institute when the religious work in mission territories. The Canon 801 of the Latin Code concerning the school apostolate also stands for the desirability of written agreements. My dear friends, the directive given by the CBCI through its circular letter to all the bishops in India in 1990 says that in the case of works entrusted by the bishop to an institute, a written agreement between the major superior and the bishop is required in accordance with the Canon 681 of the Latin Code. But in other cases, The Code of Canon Law does not oblige religious to enter into such agreements. However, considering the signs and needs of the times, it is recommended that this be done with a view to greater coordination in the apostolate in the diocese. There is no obligation for religious who have already been working in the diocese for a long time to make written agreements with the bishop regarding their existing works. However, such written agreements might sometimes be advisable, especially if misunderstandings and doubts have arisen.